Members of the jury, welcome back. You guys may have a seat. Does everyone have their notepads? Okay. All right. Well, good morning, everybody. It's good to see everybody. Hope you had a nice weekend. We're going to go ahead and get started. I have some instructions to read to you guys before we get started. Members of the jury, the defendant has been found guilty of 2 counts of first-degree murder in a previous proceeding. The only issue before you now is to determine the appropriate penalty. The penalty for each of these crimes is either life in prison without the possibility of parole or the death penalty. Before proceeding further, it will be helpful if you understand how this proceeding will be conducted. The attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. What the attorneys say during opening statements is not evidence, and you are not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant may present evidence. Witnesses may be called to testify under oath. If so, they will be examined and may be cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. This evidence, along with the evidence that you have heard during the guilt phase of the trial, is presented to you to determine whether the state has proved beyond a reasonable doubt the existence of the alleged aggravating factors. If so, you must weigh whether the proven aggravating factors are sufficient and whether the aggravating factors outweigh any mitigating circumstances the defendant proves by the greater weight of the evidence. Finally, you will decide whether the defendant should be sentenced to life in prison without the possibility of parole or to death. At the conclusion of the evidence and after argument of counsel, you will be instructed on the law that will guide your deliberations. An aggravating factor is the only circumstance recognized by Florida law that could result in a defendant receiving the death penalty. An aggravating factor increases the gravity of a crime or the harm to a victim beyond the harm inherent in every first-degree murder. You must unanimously agree that an aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your sentencing decision. The aggravating factors alleged by the state in this case are as follows. The following aggravating factors apply to both counts 1 and 2 unless otherwise noted. Johnathan Quiles was previously convicted of a felony involving the use or threat of violence to another person. The crime of sexual battery is a felony involving the use or threat of violence to another person. 2. The first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. 3. The first-degree murder was especially heinous, atrocious, or cruel. This aggravating factor only applies to count 1. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily tortious to IS. 4. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the crime of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. The unborn child of IS was a person less than 12 years of age. That's for number 5. This only applies to count 2. Number 6. IS was particularly vulnerable because Johnathan Quiles stood in a position of familial or custodial authority over IS. This applies to count 1. The unborn child of IS was particularly vulnerable because Johnathan Quiles stood in a position of familial or custodial authority over the unborn child of IS. This applies to count 2. Once the state has presented evidence of the existing of aggravating factors, victim impact evidence may be presented. Such evidence is only presented to demonstrate the victim's uniqueness as an individual and the loss to the community by the victim's death. However, victim impact evidence must not be considered by you as an aggravating factor. A mitigating circumstance can be anything that might indicate the death penalty is not appropriate for the defendant. It is not limited to the facts surrounding the crime. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may indicate the death penalty is not an appropriate sentence in this case. Whether a mitigating circumstance has been proven is an individual judgment by each juror. A mitigating circumstance need not be proven beyond a reasonable doubt, but must be proven by the greater weight of the evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law. After the final instructions are given, the alternate jurors will be released and you will begin your deliberations. You should not form any definite or fixed opinion until you have heard all the evidence, the argument of the lawyers, and my instructions on the law. Until that time, you should not discuss this case among yourselves. Your decision must be based solely on the evidence or lack of evidence and the law. During the penalty phase, the court will take breaks and you are permitted to separate and go about your personal affairs. During these breaks, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about the case, tell them that you're on the jury and ask that person to stop. If that person persists, leave that person at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during breaks, but even then you must not use your devices to find out information about the case or communicate with anyone about the case or the people and places involved. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each breaks, please double check to make sure your cell phone or device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact phone number will be provided to you. The penalty phase must be tried by you only on the evidence presented in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, internet, any electronic device, or any other means at all to get information related to this case or the people and places involved. This implies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned or use the internet to look at maps or pictures to see any place discussed during the penalty phase. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. Do not let even the closest family members make comments to you or ask questions about the penalty phase. In this age of electronic communication, I want to stress again that just as you must not talk about this case face to face, You must not talk about the case by using an electronic device. You must not use phones, computers, or other devices to communicate. Do not send or accept any messages related to this case or about your jury service. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, and make inquiries on your own, I have no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence presented. Any independent investigation by a juror unfairly and improperly prevents the parties from having the opportunity that our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as jail time, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. In the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference regarding the existence of an aggravating factor or an appropriate sentence. And the fact that a defendant did not take the witness stand must not influence your sentencing decision in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure. It is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had the witness been permitted to answer. It may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will take. When such conferences occur, they will be conducted to consume as little of your time as is necessary. We'll begin with our opening statements, and State, you have the floor.